If you haven't had your lease looked at in quite a while, do it now. Now's the time. What's up, everybody? Jared Seidenberg, Pine Financial Group, coming to you from the YouTube channel, where we work together to help you succeed. Hey, if you found us here on YouTube or you found us on Facebook, give us a like, subscribe to the channel. As you know, we're trying to build a good audience here and a community, provide some content that you guys want, and the best way we can do that is by getting a bigger reach and to make sure that we're in front of as many people as we can. So help us out, give us that like or subscribe, tell your friends, tell your family. We're here for you. So, as you guys know, one of the roles that I serve around here is of the general counsel. As I told you in my last video, I'm going to start looking at some of the legislation that is going on around our state here in Colorado. I'm also going to look at some things that are going on in other markets. But, housing legislation is huge right now. This is a big talking point for politicians. It gets a lot of votes, gets a lot of attention. So, of course, this is going to be in the news. Last year in our legislative session in Colorado, 24 bills were looked at. Most of them were passed and were signed by our governor. Some of them were not. Some of them were pretty controversial. So we're going to go through, we're going to look at a couple of these things. Today, I want to talk about two bills that passed and how they change some of the things that landlords need to do. A lot of the stuff that was going on in our legislature was aimed at the landlord-tenant relationship, affordable housing, access to housing, things like that. So we're going to talk a lot about what that looks like. Of course, there are very distinct views about what should be done to regulate housing. There are a lot of people that believe that there is no affordability. People can't buy homes, so the rental relationship is more important. They want to make that more equitable. On the other side, there's a lot of people that just fervently believe in property rights and a landlord's ability to control their home. They own it, so they should be able to tell people what to do with it. Of course, there's always been some regulation around that, discrimination laws, anti-discrimination laws, as I should say. In some areas, you get rent control, you get warranty about habitability, the place has to be livable, some of these things. So it's not as though rentals have been unregulated, that housing has been unregulated, but we are seeing a movement to create more regulation around it. So, let's talk about a couple. Now, you'll see me, I'll refer to some notes here. I do not memorize this stuff, guys, because it's detailed. So you'll see me refer to some of this. The first bill that we'll talk about here, it was a Senate bill, 23-184. This has been signed by our governor. It is now the law. Right here you see I've got the act as it is written and as it's gone in. What this one does is tells people what types of information and what types of financial information they can collect and use in the process to qualify someone for their rental. So usually this stuff has not been regulated. There are a lot of people that are upset that believe that landlords overreach, that they ask for more than they should, or that they require credit reports that are burdensome and cause people's credit scores to drop. So that's what this is aimed at. So what we've got to do here is look at what you can do now as a landlord to help qualify your tenant, right? So a couple of things off the top. You cannot go back farther than 7 years in history. So someone was evicted 8 years ago, bankruptcy 8 years ago, even 7.5 years ago, financial crimes, all of those things, can't look at them. What this is intended to do is give people the ability to restart and get going again. So if you're a landlord and you're looking into some of this information, you can only go back 7 years. It's the way it is in Colorado. Our governor signed it, so we have to deal with it. So a couple of things also. If you are on a housing subsidy, meaning that the tenant is receiving a housing subsidy, you can only look at enough income to find 200% of the yearly rental value. Now, this one is a little bit controversial in that a lot of people are taught in financial education that they should be looking at 30% of their income to be part of their housing expenses. This one takes it up to 50%. But what proponents of this will say is that if you're making 2 times your rent, that's pretty good because rents are high. So at this point, that's the way it goes. Now, also, you cannot pull credit any longer if there's a rental subsidy. The idea is that the government is giving your tenant money. They should be able to pay you. Their credit worthiness is not the issue because they're not going to non-pay. It's double negative, but still, they are going to pay their bills because the government's behind them providing that. And then also, if the landlord is subsidized. Section 8, some of these things, and is getting assistance from the government for that property and is in those programs, they also cannot look for more than 2 times the rental income. So interesting stuff going on here. And also, you cannot have any financial information collected if the government is going to pay 100% of the rent. So pay attention to some of these things, guys. This will definitely impact the way you qualify your tenants. The other one that we're going to talk about real quickly, and I don't want to make this too long, but there are a whole host of new provisions about what your lease can say. So big piece of advice here, not legal advice, legal education. You're not my client, I have to tell you that. But if you are a landlord and you are using a lease that has not been reviewed by an attorney in quite some time, or really now, even in the last year, please get that lease reviewed. There are a bunch of new provisions. So let's talk about a couple of them. Right now, if you had an eviction, you can no longer charge a penalty for that eviction or that eviction notice. So you can't make an additional charge on there. What the law says now is that your remedy is the eviction. Your damages are past rent, nothing more. You get the property back, you move on, right? So you can't have that one in your lease. This is one that's been pretty controversial in the legal community. I've heard a lot of commentary about it. It has always been pretty common for a landlord to put a provision in that says that if they have to evict if they have to enforce the lease and they win, then they can get their costs back, right? So this is a fee shifting clause that only awards the fees to one party. Now, I kind of jumped the gun because they also have said that you can no longer have just a one-sided prevailing party fee shifting. So what that means is that if you challenge a lease or enforce a lease and you lose, you will pay the costs no matter which side you are. They're going to have equity there, okay? Now, also, prevailing party designations. So what it used to say is that you could have a prevailing party designation in your lease, and you could then get that money if you won. That could have been in a mediation, it could have been in a settlement negotiation. What the law says now is that you have to actually win in a court of jurisdiction, and the court has to determine that your fees are reasonable. So that's going to track just like every other civil litigation, but now this has to be baked into your lease. You can't have a provision that goes against that, okay? Now, if the tenant doesn't provide you notice and they just bail, a lot of landlords used to have a provision that assigned a penalty for that. Can't have it anymore, guys. It's gone. Now, the other one, this is something that I used to advise my clients on. I liked to have a waiver of a jury trial. I liked that to be to the bench. What a landlord's attorney will tell you is that oftentimes a judge is a little bit easier on a landlord. So if you're representing the tenant, it was very common to say, we're going to just put a waiver of jury trial and no one's going to get one because we want to do a trial to the bench. You can't do that anymore. Can't waive jury trial. If the other side wants it, if the tenant wants it, you want it, people are entitled to a jury. That's just the way it's going to be, guys. Two more here, and then we're going to close this one out. You can no longer have an excess fee for third-party billing. So if you're getting billed by the trash company and that has an extra fee attached to it because it's electronic payment or something like that, you can't pass that through. There's a lot of ramifications for this because there's certain tenants that have landlords use a third party for their rent collection and some of those things. All of those fees were passed through. What this now says is the landlord is going to bear those costs. So guys, as I said at the beginning of this, if you haven't had your lease looked at in quite a while, do it now. Now's the time. Make sure that it's compliant. Make sure that you understand the laws. And we'll be back with a little bit more of this series. Drop me a comment below, guys. Let me know what you want to hear about. I want to have this ongoing conversation. I want it to be interactive. I want to provide content that you guys like. So let me know what you're thinking. If there's something particular, I'll pick it up in the comments and we'll address it. So, all right, guys. Again, Pine Financial Group, you know how to get us. You can see the sign behind me. Oh, wait, on this side behind me over here. Find us on the web. Find us on our phone number. Get in touch with us. We're here to help you guys.